When can schools curtail students' political speech? How do we balance students' free speech rights with the need to maintain an orderly and effective school environment? Can a student be paddled for simply writing Trump 2016 on a whiteboard?
So paddling is still a thing, huh?
Apparently in the state of Alabama, yes.
On today's episode, we're going to unpack the complexities of TS versus Talladega County Board of Education, a middle school saga from the 2016 election, exploring the boundaries of authority, the nuances of free speech, and the role of parental intervention. It's a story that raises questions about politics, discipline, and the never-ending delicate dance between educators, students, and parents. This is a pretty good case to cover as another heated election season is underway. And it's Talladega County, so let's see how many Ricky Bobby quotes we can throw into this episode.
As I was reading that was all I was thinking
I know,
about.
right?
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Talking Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, we got a couple of bell ringers for you today, folks. Chris, why don't you go ahead and get us started?
So I've got one here that was actually sent to us by Sarah Flournoy. It is about a situation going on in the Seattle public schools where Seattle has made the decision to stop its current gifted and talented program, which has a number of schools that are kind of like our magnet schools from Coalition for TJ that are kind of designed for these gifted and talented students to attend. They are stopping the program, and part of the reason that was talked about at the school board meeting and for the folks kind of supporting this decision is because of concerns about the lack of diversity in these gifted and talented programs. So they're concerned that white and Asian American students are overrepresented, and so Seattle is moving away from those programs to programs that are more based on community schools, ensuring that everyone kind of has individualized learning plans to differentiate within those schools rather than having these separate magnet programs.
Well, interesting.
Yeah. So what I think is really fascinating about all this is, it connects really well to our conversation about Coalition for TJ versus Fairfax County from a couple episodes ago, where if we're thinking about this as a decision that is potentially motivated by a concern for a lack of diversity, in the same way that TJ was motivated to increase minority representation at TJ, here we've got kind of the same motivations. So if we take the logic that was rejected in TJ, that means that this decision could be subject to strict scrutiny, which would mean that it would be potentially likely, that the school board would be required to maintain these programs that they don't want to maintain because of the argument that deviating from the status quo based on concerns for promoting diversity would trigger strict scrutiny. Obviously, though, that's not the direction TJ went, but it kind of shows the implications of those arguments about basically triggering strict scrutiny every time we think about diversity, which involves also racial diversity.
Yeah. Wow.
Yeah.
I don't even know what to say about this. I'm just surprised that there are so many of these things that just keep bubbling up.
Well, the big thing is continue to put these within this larger context of efforts to curtail DEI efforts. And so here this school is acting out of a desire, it seems, to promote inclusion and to kind of ensure that its schools are culturally, ethnically diverse. And, there's a movement within the law that would kind of point towards those goals being potentially problematic, as we talked about with TJ.
Right.
So just kind of keeping an eye on stuff like this to just see how or whether courts start to look at these things differently.
Sure.
Recognizing, though, that pursuing diversity through race-neutral means is something that the Supreme Court has been pretty okay with, as we talked about in our last a couple episodes ago.
Exactly. Very cool. Well, we'll have to keep following that one. I've got one.
You've got one?
Yeah. So this,
let's go.
Yeah. This recently came out. A bill was recently signed into law in West Virginia. This is Senate Bill 280. And basically this new law. So I'll just tell you exactly what this new law says. All right.
Okay.
And because it's very short. So it says, no public school board, school superintendent, or school principal may prohibit a public school classroom teacher from responding to student inquiries or answering questions from students about scientific theories of how the universe and or life came to exist. Now.
Okay, wait. So let me unpack that a little bit.
Let's.
So it applies to basically everybody involved with public education, right? Like, so it's the superintendent all the way down to the classroom teacher.
Yeah.
And it's a prohibition on them prohibiting teachers from responding to questions about how life started. Did that make sense?
I
feel like that didn't make sense.
No, this is where I get frustrated with a lot of lawyer talk.
This is it? This is where you get frustrated?
This is one of the many areas. No, it's like, we get all caught up in these double negatives and all that nonsense. Anyway, yeah. So this prohibits school leaders from prohibiting teachers from responding to students. So basically this opens the door to allow classroom teachers to respond to student inquiries about scientific theories of how the universe and or life came to exist. Now, at first, you're probably listening to that and saying, well, what's wrong with that? Wouldn't we want people to be able to talk about scientific theories and all of that stuff?
Or we want teachers to be able to respond to students' questions, right?
Period. Yeah.
It's great when students ask questions.
Right. What supporters of this bill say is that this opens the door to teaching divine creation, intelligent design, things like that. All right. Alongside evolution.
So they're taking a very broad view of what constitutes a scientific theory then.
Yes. And the interesting thing about this, I think, and I think many others think who have reported on this, is that a 2005 ruling in federal court found that presenting intelligent design as a scientific alternative to evolution was not permissible. It was unconstitutional because it wasn't necessarily a scientific viewpoint. It was a Christian viewpoint.
Right.
So this was a 2005 federal ruling that basically said creationism or intelligent design is not a valid scientific approach. And so this is yet another example of one of these vaguely worded, well, or maybe it's not,
I was going to say, this one's not even vague. They're trying to redefine terms, right? Like they're trying to define a term in such a way as to be over-inclusive, perhaps, right?
I guess what I'm saying is that it seems like the supporters of this bill are banking on sort of like interpreting this bill in a very loose, vague kind of way, right?
Right. Or making educators worried about like, okay, well, now I've got to evaluate, is that a scientific-based theory? Like, am I now allowed to respond to it or not prohibited from responding to it?
Right.
Yeah. And so like, this is one of those examples where, Jamie, to your point, like the law is really vague and it comes on the heels of other efforts to inject intelligent design into the science curriculum that have been largely unsuccessful.
Yeah.
And so like, maybe we need to start thinking about these kind of laws as like hydra laws, where you lop off one head and two more pop up. They just have like slightly different wording, I guess, like, cause it's all trying to get the same thing, but like this is a different way of doing it. So instead of saying like, hey, you have to teach intelligent design, or hey, you can't teach evolution, which, those haven't been successful, or, it also hasn't been successful to say you have to give equal weight to creationism and evolution.
Mm-hmm.
Like all of those have been struck down by courts as kind of trying to promote religious ideology in the science curriculum.
Yeah.
But now here we've got, we lopped off those heads, and now here's another one that pops up, which
looks just a little different.
Looks just different enough because it's a prohibition against prohibitions rather than a affirmative obligation, I guess.
Yeah.
And so, that's just like, it's so weird. These laws, because of how they're written, like, how do you enforce this?
Right.
Right? Like,
well,
you would have to have a principal say you're forbidden to respond to questions about creationism. And I don't know of any principal who says that. Like,
I wonder what would happen if a student starts asking questions and the science teacher refuses themselves to answer. The law, it wouldn't apply, right?
Yeah, because they're not prohibited from responding. They've chosen not to respond. Because it doesn't say you must respond. It says you must not tell them not to respond.
Exactly. So, wow.
Which is just going to go like, you and I here are parsing this out, right? But like, if you don't read the law itself, if you just go by the popular rhetoric around the law, these teachers are like now worried, like, hey, if I
say
don't
anything,
talk about this stuff, or if I, fall in the wrong line of this, then I'm going to be in legal trouble. And that to me is kind of the biggest thing, is because like, we talk a lot about the chilling effect of these laws, where these teachers who don't necessarily have the same skill set that you and I have are expected to navigate these things in their daily practice. And, they're not necessarily prepared to kind of walk the gray areas as you and I might be able to do. And so like, they're going to overcorrect, they're going to self-censor, or they're going to, go the other direction and like inject these conversations into the curriculum when, maybe they shouldn't be there.
Right. And this is why, this is why we've said it so many times, but this is why we do the show. This is why, we do a lot of the work and the research that we do is about, digging into some of these things so that we can empower teachers to not just fall back on the popular rhetoric that might be out there surrounding some of the things that have implications for them, right? And that they could potentially read something like this and say, you know what? I don't have to respond to a student.
Yeah. They can be empowered to read something like this and go, that doesn't do anything, right?
Right. Or on the flip side, there can be a teacher who chooses to respond to a student in maybe a very bold kind of way that potentially teaches this particular concept, which again, the courts have kind of repeatedly struck down, but even that wouldn't necessarily be a violation of this law, this particular law.
Right.
Could be a violation of others. Man, hydra laws, Chris, nice. I like that one. That's
TM.
Yeah. Does that count from a legal perspective to just say TM over and over and over again?
I didn't take that class.
All right. So if other people start using hydra laws and we don't get royalty checks.
No, just, give us a citation. Thomas and Cudlitz, 2024.
Oh, man. Okay. Well, we'll see how that one might go somewhere. It might not. We'll see. Let's talk about this week's case. How about that?
Let's shake and bake, baby.
Oh, nice. All right. We're gonna do this.
All right, that's one.
We're gonna do this as quickly as we possibly can because I want to go fast.
That's 2 Talladega Nights references. Yep, I'll take it.
All right. Well, hopefully no one else has really spent a lot of time talking about this case, and so we're gonna be the first one. Because you know what?
Right. Because if you ain't first, you're last.
God. Okay. I think we've hit our quota. Probably also because
they're too close together. We got to space them out.
I know. But I think we're probably done at this point because I think every other quote from that movie is inappropriate, or at least would invalidate our clean podcast rating.
That's right. We've worked very hard on that after the Mahanoy case too.
All right. So let's go down to Ricky Bobby country in Talladega County, Alabama. This all took place right around the 2016 election, sort of right before and right after the election took place. So November-ish 2016.
Mhm.
And what we've got a middle school in Talladega County. The main characters here are the assistant principal, Bynum, and he was actually acting as the principal at the time because the principal was on leave. So the main administrative figure here is AP Bynum. We've got a couple of classroom teachers, and then we've got an 8th grade student named TS. All right. Or those are his initials.
Mhm.
So what happened was, in the days leading up to the election, AP Bynum had heard reports of disruptions and unrest in other schools from around the area in regards to the presidential election. And, I'm sure that most folks listening to this podcast, especially if you're teachers, probably have some pretty vivid recollections of what the school climates were like around the 2016 election. So he heard reports of disruptions and unrest from other schools. And one day after the election, Bynum received a report that students at that middle school, Childersburg Middle School, were, quote, wound up about the election and were very loud and rowdy in the halls, unquote.
Mhm.
And he said that this caused, quote, disruption in the hall regarding the election results.
It's going back to like the vague language here. Like, what does it mean for a disruption in the halls? Like, I've been in middle school hallways. I don't know if I've ever described them as calm and tranquil.
Well, I think it's a matter, like everything's relative, right? And like, so you're talking to somebody here who spent 15 years in a middle school.
Right. Yeah.
As both a teacher and administrator. And while I agree, like hallway stuff is often quite chaotic. If you've been in a middle school for long enough, you can kind of tell when things are shifting.
What's a normal rowdy versus an unruly rowdy?
Exactly. And I guess in this particular case, we kind of have to take the assistant principal's word
Mhm.
for what he might have felt was transitioning from normal to not normal.
Right.
Well,
and that's going to be really significant when we talk about whether or not the school was justified in doing what it did.
Yeah.
Is just like how disruptive this conduct was,
Right.
and like how much of a fear of this disruption
Right.
we were expecting. So like
Right.
that, I'm just kind of foreshadowing. Like,
yeah.
I want more. I need more evidence.
Okay. Well, I'm going to give you a little bit.
All right.
It might not be the evidence you're looking for. These aren't the droids you're looking for. Sorry. That was not from Talladega Nights. So basically, we're setting the stage. We've got potential disruption, rowdiness, loudness
Mhm.
in the halls here, all surrounding the election results. Okay.
Right.
And so what the AP decided to do here was to create a rule that limited discussions about the election to history class. Okay. So what he was kind of going for here was, let's just put that into the environment where we can kind of, as a school, where we can manage those discussions, because
Mhm.
outside of those environments, in the hallways or, other classes or whatever, things could potentially get out of hand. I'm sort of like,
Mhm.
I'm assuming, I'm kind of interpreting based on what I've read about
Right.
this, that was sort of the mindset, right?
Right.
So what he did was he asked another teacher to go ahead and make an announcement, I guess over the PA or something like that.
Mhm.
And it was sort of a general announcement that just said all discussions of the election should take place only in history classrooms so as not to disrupt other classes or the hallways. So that teacher did that. They made that announcement and also mentioned that doing so or violating this particular rule could be grounds for discipline. Okay.
Okay.
So that's the backdrop.
Right. And I understand the reason for the policy, right? Because you don't want there to be fights or disruption in the hallways based on
Mm-hmm.
these students kind of getting into it in a political discussion that,
Pretty heated.
either might get, it might get heated. Because, I remember after the 2016 election, there was a lot of people who were very excited. And, on the flip side, there were a lot of people who were very disappointed with how that election went. So I understand that emotions were running really high here.
Right.
Whether or not this was the best way to handle it or the most constitutional way to handle it, I'll leave that
to the second half of the episode.
for the second half of the episode.
So that was the backdrop. And what happened was Our 8th grade student, TS, decided to do something that broke that rule. Okay. So what happens here in this school is at the beginning of the day, students are to report to their first period class first for homeroom. Okay. So their homeroom class is their first period class. So they go to the classroom where they're going to have first period, and a certain amount of time at the beginning is set aside for what they call homeroom. And that's the place, anybody who's spent any time in a middle school is pretty familiar with this. They make announcements in homeroom. It's when the teachers take attendance. And, depending on how long this particular homeroom period, so to speak, lasts, students can also work on academics. They can finish their homework. They can do stuff like that, right?
But they're free to do whatever, right? Like,
well,
as long as they're in the room?
I mean,
like they can talk to their friends?
I don't know.
Okay.
Okay. It doesn't go into detail in the court case. And what I will say is that, every middle school likely handles this a little differently. In fact, within middle schools, something like this could potentially be handled very differently from teacher to teacher. Like, I've seen schools where you've got this homeroom period and you walk into one class and it feels like it's utter chaos, right?
Yeah. Lord of the Flies.
Yeah, exactly. And you walk into another class and like you could hear a pin drop, right?
Right. Okay.
So, I don't know, but, I think from what I gathered from reading the details in this court case, it just describes this homeroom period as when teachers take attendance, they make announcements, and students work on academic assignments. Okay. So that's what homeroom looks like.
Right.
Now, what TS decided to do on the day in question was not report to his homeroom. Okay.
And this is what, 2 days after the election? Is that right?
2 days after the election.
Okay.
He was supposed to go to Miss Montgomery's classroom. Okay. That was his first period. That was his homeroom. That's where he should have gone. Instead, TS went to Miss Foy's classroom, Foy, did not have permission to do so from anybody, just kind of walked into another classroom that he shouldn't have been in.
Right.
And he wrote Trump 2016 on Miss Foy's whiteboard. Okay.
Okay.
Now.
But this isn't where he's supposed to be, right?
No.
Like he is.
No.
Okay.
And he had he had not told anybody or asked anybody, to go there or to leave Miss Montgomery's classroom. He didn't even show up to Miss Montgomery's classroom. He just went straight to Miss Foy's. He just walked into another classroom. All right. So writing Trump 2016 on the board, according to TS, caused a lot of arguing in the class. And a handful of the 15 students who were in there at the time were upset about what he wrote on the board. And when other students complained about it, TS, quote, argued a bit, unquote, with those other students and, quote, rubbed it in their face that President Trump won.
Okay.
So
that answers my question. I was thinking, like, why did TS go into this classroom to write this on the board? Like, what was it?
To stir some what?
Right, because why is he in Miss Foy's classroom when he should be in his homeroom? And then, he obviously chose to write this particular message. So, like, if we're climbing into TS's head.
Yeah, I don't think he was there to engage in a respectful academic dialogue.
About political philosophy.
No, exactly.
Yeah, right. Yeah, okay.
Also, don't forget, TS is an 8th grader in a middle school. And,
right.
Again, I'm pretty sure he was going in there to just kind of stir things up a little bit. Okay.
Yeah.
Anyway, what happened was he left the room and he went to the bathroom. And after he got out of the bathroom, Miss Foy approached him in the hallway and told him that he should not have written Trump 2016 on her whiteboard because it started a lot of fights and argument. She walked TS back to Miss Montgomery's class where he should have been in the first place and told Miss Montgomery what happened. Then she issued a discipline referral to TS.
I think this is where you lose me, but keep going.
Okay. So here's what the discipline referral said. Students were told yesterday, because of the sensitivity of the matter, not to discuss the election unless it was in history class. They were told any discussion would result in office referral. TS decided to write Trump on my board this morning disregarding others that were in the classroom. This resulted in some upset students. I informed the student that the name, it could have been the name of the other candidate, wasn't the issue, but it was the nature of everything behind it. So that was the office referral. And so what the teacher was basically saying was, when I spoke to TS about this, it wasn't about the fact that he wrote Trump on the board. He could have written Clinton. It wasn't about that. The point she was trying to make. Oh my gosh,
I almost said Biden.
Yeah, no.
Oh, yeah.
We're 2016.
Okay.
Yeah, I know. I had to check myself too. So, she said that it wasn't about that. She said that this was about essentially it was about breaking the rule and causing the disruption. Okay. Is what she was basically saying.
Right. Yeah. And that makes sense, right? Because it would be even more problematic to punish a student for their political viewpoint. Like that would be a huge, huge problem. Here she's focusing on this disruption. My thought though is the student isn't where he's supposed to be, right? Like he's not in his homeroom. He has no legitimate reason to be in Miss Foy's classroom at all. If you're going to punish him, like if you're going to discipline him, why discipline him for his speech of writing Trump 2016 on the whiteboard?
I'm going to go out on a limb and answer that.
Go for it, please.
And again, I am making a lot of assumptions here as to how this whole homeroom process works.
Yeah.
I don't know for sure. Again, every school is different. Every teacher is different. My guess is that it's a pretty, those first few minutes are potentially a pretty loose time of the day. And maybe you've got other kids who go into other classrooms, maybe to, hand their friend something, or, go in and just relay a quick message and then, jump out and go back to their homeroom. I wouldn't be surprised if it was loose to the degree where a teacher might not have felt comfortable disciplining a student for breaking that rule, because that would open a whole can of worms about all the other students who might need to be disciplined.
Do it too. Okay.
But again, I'm guessing.
Yeah.
I don't know. So maybe that's why they chose to focus on the disruption.
Yeah. So focusing on the disruption, obviously that's kind of the strongest argument here.
And that's the one they decided to go with. And that's the one the court decided to, we'll talk about it later, but that's essentially what the court decided to kind of focus on.
But, Jamie, to respond to your argument, we want to make sure that we're enforcing rules consistently, but just because we've the rule is still on the book, right? Even those kids who are doing this thing, if there's a rule on the book that says don't be where you're not supposed to be, it's still there.
Yeah. I mean, but the realities of what we deal with in schools, the pick your battle mentality does come up quite a bit. And it has to and honestly, to maintain, maybe it's kind of ironic or whatever, but to maintain order and efficiency and everything, I think
you have to accept a little bit of
picking your battles is important.
Yeah, no, I totally get it.
All right. So TS goes to the assistant principal Bynum's office, and Bynum was told that TS was written up for causing commotion in Miss Foy's classroom, and Mr. Bynum didn't say anything about the presidential candidates themselves. Okay, in his discussion with TS. So similarly to Miss Foy, the approach that Bynum was taking with TS this wasn't about Trump or Clinton or whatever. It was about the fact that you broke a rule and disrupted the educational environment. All right?
Right.
So this is where it starts to get a little funkier now. So Dad gets involved. So Bynum called TS's father and explained what TS had done, and that as punishment, Bynum planned to either paddle TS or give him an in-school suspension.
Now, Jamie, this isn't going to be another one of those cases where we've got this student discipline issue that then pivots into a parent behaving badly, is it?
You know what? I'm going to say no on this, at least my reading of it. There were some articles that came out when this story happened that sort of quoted Dad and and really made clear Dad's feelings about the issue. And Dad, it's perfectly clear Dad was not happy about TS being disciplined in any way for this speech. Okay, but
understandable.
I didn't get any sense that Dad behaved inappropriately towards the school.
Okay, cool.
Right?
So This is a student case then.
Right. Purely student case. So he basically told the father that here are the two discipline options. You can either get paddled or you can get an in-school suspension. And the father on the phone told Bynum that he didn't believe that TS should be punished at all for what happened. But if Bynum needed to take action right away, then TS could decide which punishment he wanted to receive. So just to back out really quickly, I don't think we need to spend much time on it at all, but corporal punishment, paddling, is still legal in many, many states, believe it or not. Although most of those states, the districts have kind of banned it or outlawed it or whatever. Even in states where it's legal, I would say most districts do not have this as an actual practice.
Right. Or you can only do it in certain limited situations with certain procedural protections, things like that.
And this is one of them, right? Like, so this is,
right.
The courts have again, we're not going to go into the detail, but the courts have repeatedly upheld the constitutionality of corporal punishment as long as, appropriate due process is followed. Parents receive notification, kids know what kinds of actions could result in corporal punishment, that it's not excessive. There's a lot of boundaries on it,
right?
But technically it is still constitutional.
Right. And if I remember correctly, in this case, the father had signed a consent form to allow his child to be paddled as punishment.
Yes.
And so like the parent had consented to that at the beginning of the year.
Yes. He had. And so TS decided that he would go the paddling route just to get the whole thing over with. He had also already had an ISS at some point, so he might not have wanted another one on his record. So he decided to go with the paddling.
Okay.
So he got 2 licks with the paddle. He didn't cry during the paddling. And when he was asked in the deposition about how hard the licks were, he testified that, quote, "It wasn't too bad." All right. All of this takes place during first period. Okay, so like this sort of reinforces the fact that these things happen pretty quickly. He goes into his first period class, he writes this on the whiteboard, goes to the bathroom, gets confronted by the teacher afterwards, gets sent to the principal's office. Principal calls dad. Dad leaves the choice up to TS. TS chooses to be paddled, and all of that happens in first period. All right, and then TS goes back to class. Now he goes back to his second period class.
Which is
with Miss Foy.
Yeah. So maybe that answers the question of why he went into Miss Foy's classroom. I'm wondering here, like context, right? Like, had there been conversations in that classroom about the political election?
Maybe.
Like, was there something about Miss Foy herself that made him want to write that on her board? Like, or were there students in the class that he wanted to, kind of needle a little bit?
Yeah.
So like, I'm just trying to get the fuller picture here.
Yeah. So he went to his second period class, which was with Miss Foy. And on his own initiative, he apologized to Miss Foy for his behavior. Okay.
Good kid.
Well, nobody told him to, you need to go apologize to Miss Foy. He just apologized. All right. Very shortly after Miss Foy's second period class started, TS was called to the office because his mom had come to the school to check him out for the day.
I think it was a result of the incident where the dad said,
"Wait until my wife gets there." Yeah. I mean, we're kind of assuming that this was not a planned pickup. So according to the court report, it says that TS was not in pain when he left school. He didn't have bruises. He could walk normally. He didn't need medical treatment or counseling as a result of the paddling. And, the reason we mention all that is because those are the kinds of things that courts look at, right? When they're looking at the constitutionality of corporal punishment. So he goes home, he comes back to school the next day, he finishes the school year at the middle school, didn't have any other problems with Mr. Bynum or Miss Foy, so everything's okay and all was said and done, right? No.
I mean, that seems like, if there's no further issues, like, I don't know what you want me to talk about.
Well, Dad was, like we said, Dad was not happy about this. He was pretty mad. And he said to a reporter who was, following up on this story after the case came out, was that this was just a matter of writing the president's name, and somebody should not get in trouble just for writing the president's name.
Mm-hmm.
He was quoted as saying, "I don't have a problem with paddling. I signed the consent form. It just needs to fit the crime. I mean, I don't think he really did anything wrong. I mean, there is nothing wrong with discussing what happened."
Mm-hmm.
Now, that's what the father said. It's important to note here that the school had been talking about the election for the weeks leading up to the election, and they were asking kids
Right.
to critically engage with what was going on. And Dad's position, which is totally normal in a situation like this,
Mm-hmm.
and Dad's position was, you were engaging the children in these kinds of discussions. What did you expect was going to happen? Kids are going to want to
Right.
engage in those discussions. Now, my counterpoint would be sort of what I said earlier. I don't get the impression that TS was trying to engage in an intellectual discussion by doing what he did,
Right.
right?
Well, it seems like a continuation of a previous intellectual discussion based on, his preferred candidate winning.
Yeah. So that is what led to the dad saying, you know what? I've got a lot of problems with this, and I'm going to take this to court.
Right. And yeah, this is one of the ones where that seemed like it could have been the end of it because it was almost this all's well that ends well sort of thing. But Jamie, to your point, I think these parents were pretty upset about the situation, especially given the nature of the speech.
Right.
He wrote Trump 2016 on the board. That was 2 days after Trump had been elected president. I can see why this parent would be pretty upset if that was the reason the child got punished.
Right.
So in this lawsuit, TS makes a number of claims. This isn't going to be one of those cases where we've only got one claim. This is a hodgepodge of different legal theories. So first up, we've got a First Amendment free speech claim saying that TS's First Amendment rights were violated when the principal or the assistant principal put in this policy about not discussing the election outside of history class, and also in punishing him for writing Trump 2016 on the whiteboard. And then we've got a 14th Amendment due process claim for the paddling, arguing that that was excessive and violated his substantive due process rights. And then there's a number of state law claims for assault, battery, and intentional infliction of emotional distress, all against the assistant principal related to the paddling. So we've got a lot of claims here.
Mm-hmm.
And this decision that we're talking about today is from the trial court. So we're dealing with the district defendant's motion for summary judgment. So the teachers in the school are filing for summary judgment to say there's not enough to keep moving on. We win as a matter of law.
Mm-hmm.
So we're in the U.S. District Court for the Northern District of Alabama before Judge Anne Marie Carney Axon. Jamie, guess who appointed Judge Axon?
I'm going to go out on a limb here and say, well, it's not much of a limb because I know the answer. It was President Trump.
It was President Trump. Yeah, I just think that is a really fun little factoid here. So we've got this child who was disciplined for writing Trump 2016, and we've got the judge who was actually appointed by the president whose name was written on the whiteboard.
Yes.
So I just think that's really interesting. What's even more interesting, perhaps, though, is the judge grants the motion to dismiss. And
sides with the school, huh?
yeah, the students' constitutional rights were not violated. Therefore, the school, you win.
Wow.
Yeah. So, it's a little more interesting now, given that context, right?
A little bit. Yeah, I think so.
So it starts off, as many of these cases do, with a conversation about whether or not the school officials are entitled to qualified immunity. We've talked about qualified immunity a lot in these sorts of cases, but that's the argument that the teacher and the principal and the school are making, is that they deserve qualified immunity because they didn't violate a clearly established constitutional right. And so qualified immunity protects government officials who are kind of engaging in their discretionary functions from lawsuits unless they violate clearly established rights of which a reasonable person would know. And that, again, to kind of reiterate the purpose behind qualified immunity, helps ensure that, they're free to do their jobs without kind of second guessing all of their decisions, but it also holds them accountable to know people's rights and to respect those rights when they are established by the courts.
Yes.
In order to get around qualified immunity, you have to demonstrate that your constitutional rights were violated and that those rights were clearly established.
Yeah.
And here, we're not worried necessarily about whether those rights were clearly established because the court comes back and says there's no constitutional violation here.
Yeah.
So looking at the First Amendment claims and the 14th Amendment claims, there's no constitutional violation.
Right.
So turning to the First Amendment claim, there's really kind of two issues here that the court has to deal with. One is the question of, is the policy itself about limiting discussions of the presidential election to the history classroom, is that policy itself constitutional? And then second, is the application of that policy to TS constitutional? Or did that violate his free speech rights? Putting my cards on the table, I have a lot of thoughts about this.
Well, and I've got cards too, and I will place them on the table as well.
All right, we'll see who's got the royal flush. All right. So the court starts with Tinker. And, there's that famous line from Tinker: students do not shed their constitutional rights to freedom of speech or freedom of expression at the schoolhouse gate. But the flip side of that statement is that constitutional rights of students in public schools are not automatically coextensive with the rights of adults in other settings, and students' rights must be applied in light of the special characteristics of the school environment.
Yeah. So
we've got this.
Sorry. So I was just going to coextensive, and all that stuff. So basically what it's saying is students have free speech rights, but they're not unlimited and they're not the same as the free speech rights that you and I as adults outside of schools have. Schools are specific contexts, and thus speech can be treated slightly differently in those contexts. That's basically what it's saying, right?
Right, exactly. Yeah, there's things that are special about schools that make it so that students don't have the same kind of freedom of speech that they would have in other places,
right?
In other situations. So, special characteristics. My advisor at Ohio State actually wrote a book outlining 7 special characteristics of school context. So that's Dr. Brian Warnick. Great book, Understanding Students' Rights. And so age and maturity, compulsory attendance, educational goals, parental rights, educational mission, all of those things kind of come together to kind of mediate students' rights in these contexts.
Okay.
And so that's a big concern because we don't want the students to be able to kind of through their speech, run the school.
Right.
We want schools to still be productive environments for learning.
Right.
My counter to that argument, though, is always student speech is itself educative, where through student speech, students are learning important lessons about political discourse and what it means to be a citizen and all of that. So to me, there's always educational concerns on both sides of this equation.
Well, of course.
So the other issue here is not just kind of what rights students have to free speech in schools, but also what kind of speech is this? Because the kind of speech also mediates how strongly protected it is.
Yeah. And it's political speech, which is pretty much the highest, right?
It's at the very tippy top, right?
Yep.
At the very apex, I think is what the Supreme Court has said in the past. And so it's not lewd or indecent. It's not promoting illegal drug use. It's not the school speech because it was purely the student's private political speech. So that is a huge kind of...
It's a high bar.
Yeah, it's a feather in the student's cap here for kind of supporting the free speech rights.
It's a high bar that you have to meet in order to curtail that kind of speech, right?
Right, exactly. And so in Tinker, which we've talked about in other episodes, the Vietnam armband case from the 1960s, the Supreme Court articulated the standard that you can't suppress student speech unless you, as the school leader, reasonably conclude that the speech will materially and substantially disrupt the work and discipline of the school or invade the rights of others.
Yep.
So that's the Tinker standard. Yep. We've got to point to some expectation or reasonable expectation that a material and substantial disruption will be caused or was caused by the speech.
Right.
And so applying that standard, the court looks at the situation here, starting with the policy, and says, you know what? That policy was justified. This assistant principal enacted the policy because they had reports of disruption and unrest at other schools. The day after the election, they had received reports that students at the middle school itself were wound up about the election results, were very loud and rowdy in the halls. And all of that kind of put together, according to the court here, that could reasonably have led Mr. Bynum to forecast a substantial disruption. So therefore, the policy limiting discussions of the election to the history class, that's constitutional under Tinker.
Because they weren't completely restraining or restricting the speech. They were just sort of compartmentalizing it.
Right.
To
that's
manage potential disruption.
Right. And that's one of the things that the court kind of points to is, they're not completely forbidden from talking about it. They still have this outlet. So it's not a complete kind of ban on the content of talking about this presidential election. It's also not viewpoint discrimination, right? So it's not saying you can't talk about one candidate or over another, because that would be really problematic as well.
Right.
And it kind of furthers the concern of Tinker, which was maintaining kind of the order and decorum of the school so that it's still a sound educational environment.
Right.
And I think all of those things kind of point towards, finding that the policy was constitutional. My counter argument, though, is we got to be really careful about the wording of Tinker, because Tinker talks about a material and substantial disruption. Whereas here, I don't know if there's enough, because one, the concern was disruption of unrest at other schools. So different context, not our school. And also the only evidence that we have that something was going on at this middle school is that one statement about students being wound up and very loud and rowdy in the halls. Students can be loud and rowdy after the Super Bowl, right? Emotions run high. That doesn't necessarily mean that there's a disruption. And it doesn't necessarily mean that disruption is material and substantial.
Well, but again, those, material and substantial are pretty subjective terms, right?
To use my favorite term, they're squishy terms. But the last thing I'll say about that is that there's a line from the Tinker case itself that basically says that you can't act out of some undifferentiated fear that a disturbance is going to take place in order to curtail someone else's freedom of expression.
So say that again, undifferentiated? Is that?
Undifferentiated fear. Yeah. So basically, you can't just have this desire to avoid controversy from unpopular speech.
But couldn't you clearly make the argument that this wasn't undifferentiated fear? This was differentiated? Well, there was grounds for that concern, right?
Well, maybe, but is people being a little bit louder in the hallway a material and substantial disruption?
Well, but was it for sure just a little bit louder in the hallway?
Well, and that is the crux of one of my complaints about this case. So remember, we are at the stage of defending a motion for summary judgment.
So we have to clearly articulate the facts here, right?
Right.
Yeah.
So because we are talking about this, typically what you do in this case is, or in the situation of a motion for summary judgment, is you assume all factual kind of ambiguity or all inferences are drawn in favor of the non-moving party. So that means that if we've got questions about facts, we need to resolve those in favor of the student. And here, I think that is...
What does that mean by non-moving party?
The person who's not asking for summary judgment.
Okay.
So here, the school is the one asking for summary judgment. The student is the one defending the motion.
Got it.
And so all inferences have to be drawn in favor of the student. And here, the court says that it was reasonable for Mr. Bynum to make the decision that he made.
So you could interpret that as being deferential to the school and not...
Exactly.
Okay.
Right. Because what the court should be asking is there a reasonable juror who could find that what he did was unreasonable? And I feel like I'm a reasonable person. And I think that policy could potentially be unreasonable, just given what I know so far.
Okay.
And also given the importance of the speech, because this is as we talked about earlier, the purest form of political speech.
Listen, as somebody who, read through this case and everything, and I would say if I had to fall on one side or the other, I would fall on the side of support of the school, but I hear exactly what you're saying.
Mm-hmm.
I mean, if there's anything that's potentially wishy-washy or uncertain, if we've got to look at that, paying particular deference to the student, I can see that.
Right. Maybe we should let this thing go to a trial so that someone else, or we get more information.
Or we should get more
facts.
Information. Exactly.
Exactly.
Right.
Yeah.
I get that.
And
yeah.
the last thing I'll say about that, whether or not the policy was justified, is there's this line from Tinker where The court says that the school must be able to show that its actions were caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompanies an unpopular viewpoint.
Oh.
And so there's this balance we have to strike between, like, you have to accept that some speech is going to be unpopular and it's going to be uncomfortable and it's going to be unpleasant.
Yep.
You don't have to accept, though, this material and substantial disruption. And there's a line somewhere between those two things where, the speech goes from protected to unprotected. And, like this desire to avoid the unpleasantness, because we know that, like, there's always a chance that someone expressing unpopular views may start an argument or cause a disturbance.
Mm-hmm.
And that's just something that the First Amendment, like, balances those interests in favor of more speech rather than less speech.
So, I mean, if you listen, like I said before, if I had to fall on one side or the other, I'd probably fall on the side of the school. But at the same time, if this case played out such that the motion for summary judgment was not granted and the case continued, I don't know if I would have a problem with that. Right? Now, maybe what would, if what happened as a result was that, the facts of the case were more clearly established in terms of the potential for disruption and things like that, maybe more of us, the two of us, could potentially get on board with an outcome that favors the school. But I completely see that at this stage of the game, there's some potential question here as to whether or not the standards for granting a summary judgment were appropriately met. Right? I get that.
And that also shows just how important it is for schools and school leaders to document all of these things. So, like,
100%.
If you have to defend this in court, like, you need to be able to point to, here's why I was forecasting a substantial disruption. And, the principal here very well may have that documentation and might have the receipts to kind of defend this policy. Obviously we just have the court decision.
But essentially, there's a potential that you could look at this and, like, by having that summary judgment, the school could have gotten very lucky, right? Like, because like you said, there's a possibility that if this continued, maybe they didn't have the receipts. Right?
And maybe we'll never know. Yeah, and I don't think it was appealed.
I don't think it was either, but they could take it up at the state level, right?
They could bring the state claims. The constitutional claims were dismissed with prejudice, so they can't get refiled.
Okay. They can get they can get appealed though, right?
Right, but they probably missed their window to appeal.
Okay.
All right, so let's talk about the other issue with the free speech. So the other issue is, like, putting the policy itself aside, was the application of that policy to TS, did that violate his First Amendment rights? And so the court looks at this, applies the exact same Tinker substantial disruption standard, and says that TS's speech actually did cause a disruption. It was, there's undisputed evidence that he was in this teacher's room without permission. He wrote Trump 2016 on the board. He heard a lot of arguing. A handful of students started to kind of get upset.
And he said he wanted to rub it in their face.
And then he rubbed it in their face because they didn't want President Trump to win. And so all of those things were going on. And then even after TS left the classroom, according to the teacher, the students were still arguing and talking loudly about the presidential election. And it took several minutes to regain control and get the students quieted down. So the court looks at that and says, you know what? That's a disruption that interfered with school activities and disturbed the order of the school operations. So therefore, the speech here was not protected.
Right. Now, I don't know, several minutes in an 8th grade classroom it can be like a lifetime, man.
All right, I'm not going to argue that point. But words matter. Was that a material and substantial disruption?
Well,
right? Like, it's a few minutes.
And what were they doing in that class where that discussion or that disruption materially or substantially disrupted what they were doing? Right?
Yeah. Was it a Lord of the Flies classroom? Or
like if they were in the middle of taking a test, for example.
Huge. That could be
Right?
material
That
and
could
substantial
be
disruption. Yeah.
huge. But, again, like if it was, just this sort of casual environment where everybody's going in and out and doing their own thing. And like, how much was that really a disruption? I
Right.
totally get that.
Yeah. And that's because all of this is a balancing act, right? We're trying to balance
Sure.
free speech against these educational concerns.
Sure.
I tend to fall on the side of allow the speech and address the speech with more speech, essentially. But, I think that it's a difficult balance to strike. And I don't want to discount the experiences of school leaders and educators who have to navigate it on a daily basis because student speech is disruptive, right? Like
Right.
it disrupts the process.
Right.
And that I think is the strongest argument to curtail student speech. Here, I just don't know.
No, I get it. I think there's just some facts here that are to claim that they're undisputable would be pretty problematic.
Right. Or that no reasonable person could differ on their.
Yeah.
I could totally see a reasonable juror saying that doesn't seem like a material and substantial disruption here.
Yeah.
But the last thing I'll say about the free speech issue is the court ends their discussion with something that I think is really, really odd. So we've talked a lot about Tinker, and the court ends by citing to Justice Black's dissent in Tinker. So this is not the majority opinion. This is the person who would have come out differently on whether or not Tinker's speech was protected.
So this is the person who would have decided that Tinker's speech was not protected.
Correct.
That the school had more authority
Than the majority thought.
thought. Okay.
Right.
Okay.
And so the court ends their discussion by quoting to Justice Black's dissent to say that to hold otherwise, meaning to hold for TS here, would usher in an entirely new era in which the power to control pupils would effectively be transferred to the courts.
Wow. So that basically what that is saying is if we ruled for the student, then we're taking away all of the authority and control from the school administrators. So basically, the school administrators can no longer judge or interpret or decide about what should happen when a student potentially breaks a rule. They have no more power. So the only people who could step in is the court system.
Right. Everyone, anytime you discipline a student, they're going to bring a lawsuit and the courts are ultimately going to decide whether the discipline should stand or not.
Yeah.
Yeah. So that was Justice Black's point in his dissent from Tinker. And the court here cites that approvingly to say, if we found for TS, then we're basically ceding control over the schools to courts. But the whole line from Justice Black dissenting in Tinker is that the court's holding in this case ushers in what I deem to be an entirely new era. So it's this weird thing where you're citing the dissent to the case that you just relied on to find for the school when Tinker found for the student. It's a very strange citation.
It's almost like they're using both sides of the Tinker argument to justify their decision.
Right.
And both sides of the Tinker argument are sort of at odds with one another.
Exactly.
That's crazy.
Yeah. I saw that and I immediately just kind of paused. I was like, why would you cite to the dissent when the dissent is not binding and judge the values here a little bit differently than the majority? So anywho, that's neither here nor there, but it's interesting.
Yeah, totally.
So, the last thing is this corporal punishment issue, which is, largely straightforward in ways that I don't think the free speech stuff is.
No.
Because corporal punishment, we've talked about it. It's still allowed in many states. The Supreme Court hasn't, there was a case that upheld its constitutionality. And essentially to demonstrate that corporal punishment violates the Constitution, you have to show that it is arbitrary or conscious shocking, which is a very high standard where you basically have to show that the conduct shocks the conscience. And in order to do that, you kind of have to demonstrate that the school official intentionally used an amount of force that was obviously excessive under the circumstances, and that the force used presented a reasonably foreseeable risk of serious bodily injury. Yeah.
And there's also stuff about there's stuff from these corporal punishment cases that talks about ensuring that the administrator isn't angry or you got to make sure that they don't have it out for this kid, right? Like there's some high bars that you have to meet. And I think that's one of the reasons why the vast majority of school districts and states do not allow this practice anymore.
Right. This is not a situation where I think the court necessarily applied the standard wrong. It's just the standard itself seems, problematic, just given the nature of the power imbalances between teachers and schools, and whether or not this is an appropriate form of school discipline rather than parental discipline,
and these
all of those different issues.
Yeah. And these questions keep coming up. I mean, there was that case that went to the Supreme Court recently that they denied cert on. That was about corporal punishment of a student with
a disability. Yeah.
Yeah. Student with a disability. I think it was a student on the autism spectrum. And they denied cert, which sort of upheld the lower court ruling, which was upholding the constitutionality of that discipline. So yeah, it's not a topic that we're going to spend too much time on. It's just interesting. It's another interesting layer to this case, right?
Right. Yeah. And so the court looks at it and basically says the force here wasn't excessive. We've got all this evidence that TS went to second period. The only thing we have is that he said that one of the hits hurt a good bit, but he didn't have any bruises, didn't show any signs of discomfort, didn't need medical attention, was at school the next day. All of those kind of point to the discipline not being overly excessive. And so because of that, there's no 14th Amendment violation, and the court had found that there was no First Amendment violation. So without any constitutional violations, the defendants get qualified immunity because no constitutional rights were violated. And then without the constitutional claims, the court ends up dismissing the state claims because without a federal claim to kind of get you into federal court, the court doesn't really have any reason to answer those state claims. So the court dismisses the state claims, though without prejudice, meaning that TS could refile the state claims in state court if he wanted to. Yep. And that's TS versus Talladega Nights.
Yeah. Talladega Nights.
Oh, wait. That would be a different movie.
That's a different episode, right? No, TS versus Talladega County Board of Education.
There it is.
There it is. Yeah. Shake and bake, baby. Okay. So, so that does it. Listen, I mean, I think the big takeaways here, folks, I think our discussion from this episode clearly articulates the potential gray areas that the court, some would argue, took a more definitive stance on than some folks might have taken on those particular gray areas, and, might have wanted more facts, more detail, more context to be able to better answer the questions about disruption and things like that. Again, big takeaways for school administrators: make sure you are documenting, make sure that the intention of your policies is justifiable, right? Like, make sure that what you intended to do by this policy was appropriate and was constitutional, right? And make sure that if you're going to enforce it, that it's being done for the right reasons and on substantial grounds.
Right.
Like that's that. Because again, if the court had denied summary judgment and this thing had moved on, then it could have become potentially problematic for the school if they didn't have sufficient evidence indicating that the disruption was material and substantial.
Right.
So, I think we provided some good examples and some good sort of arguments about, what homeroom kind of looked like, or what it might have looked like and might not have looked like. So, as a school, as teachers and as administrators, hopefully this is, you can kind of think through your own experience. And
right. Because context matters.
It's huge.
And
context is king.
It's everything, right?
Yep.
And I think the last thing that I would say about this is just kind of recognizing the educational values on both sides of this equation about balancing student free speech rights against the need to maintain order and discipline.
Yeah.
Like, there's educational concerns on both sides of that equation.
Totally.
Where the value of this speech is really, really important to help cultivate students, future kind of citizenship, or to kind of like just help them develop, because, it's really educational. And so if schools are going to curtail student speech for these other kind of educational concerns, going back to Dr. Warnick's book, Understanding Students' Rights, he argues that they should do so in educational ways.
Right.
So if you're going to curtail speech, do so in ways that affirms kind of the value of that speech and also gives them ample opportunities for alternative channels to engage in speech. And here, I think that was partially done, but I would love to see the school kind of do more to say, like, we really value these conversations about the political process and about the presidential election. We love that you guys are engaging and are passionate about this. Here's why we're doing what we're doing, and here's why it's appropriate to do it in this setting.
Yep.
I think that goes a long way towards affirming the value of student speech.
Yeah, I completely agree. Because, in this case, it sounds like that decision was made and it was just a simple announcement over the PA.
Mm-hmm.
Political discussions are limited to history class. And if you don't do that, you're going to be disciplined. That's a very different conversation, right? And middle schoolers are capable of engaging in that level of discourse. That's very different than maybe having an assembly or something like that, where you get up and you say exactly what you just said, Chris, right? Like, we have to maintain some sense of order and educational value when we have these conversations. So we're going to be doing it in this format. We're going to be doing it at these times. We're going to be doing it in these ways. And I think that middle school students are capable of understanding that kind of approach, right?
Right.
And reasoning. So, yeah. And I think, sort of to take your point a little bit further about that balancing act, there's a lot of schools out there that have sort of not just limited, but eliminated altogether political attire, and speech and all of that stuff for the same reasons, for disruption, avoidance, and everything. And to your point, it's viewpoint neutral and all of that stuff that it would need to be. What that does is it restricts or eliminates a very important educational opportunity.
Right. For growth and development and just kind of practicing what they're going to be asked to do as
citizens.
Yeah.
Yeah. Yeah, completely. So I'm with you there. Great discussion. This was a fun one. I like this one.
It was.
Yeah. Yeah. And it's relevant now, right?
I was going to say, I think we solved it. So I don't think that any issues like this are going to come up in 2024.
Exactly.
Yeah, I think we addressed it.
That's right. Let's wrap this thing up. What's your homework?
Your homework is to find Chalk and Gavel wherever you get your podcasts. Please like, rate, review, subscribe, all of that fun stuff. You can find us on social media at Chalk and Gavel or on our website, chalkandgavel.com. We'd love to hear from you. Love to keep the conversation going. If you have ideas for future episodes or for bell ringers, current events that we should follow or talk about on the show, we'd love to hear those. We might even get a shout out on the show. Please hit us up. We'd love to hear from you.
Yeah, and make sure that you go to your assigned homeroom first thing in the morning. Do not stop. Do not pass go.
Don't want to see any dilly-dally.
Yeah. All right, folks. That does it for today, and we'll see you on our next episode in a couple of weeks.